Welcome, everyone. My name is Greg Kim, and I also have Catherine Tashner, who is my co-founder of Business Law Corps on the video, as well as our interns, Stefanos and Christian. So thanks for their help. And we're fortunate to have Greg Ferren today as our speaker. We're talking about a topic near and dear to everyone, hopefully, which is how to protect your brand, if I could ask you to mute yourself, if you're not muted, I appreciate it. And we will take questions during the presentation and address them at the end. We found that works best. So you can put them in the chat, or if you're brave enough at the end, you can unmute yourself and ask your question live. We're gonna finish promptly at 11 our time. And so, and Greg mentioned he would stay on for a few minutes, has a few minutes afterwards to answer any follow-up questions. Let me turn it over to Kat just to give you a quick overview of our nonprofit, which is hosting this event, and then I'll come back with a few more details. So Kat, could you explain Business Law Corps a little bit?
Sure. So hi, good morning, everyone. Thank you for attending. As Greg mentioned, we're the co-founders of the Business Law Corps. It's a nonprofit organization that provides free legal services to small businesses and entrepreneurs here in Hawaii. So we hope, as you develop your business ideas and as you grow your business, we can be a resource to you. Some of the services that we provide are, providing webinars or seminars like this. We also have free 30-minute appointments every week where you can sit down and talk to a lawyer and ask them kind of your specific legal questions. We host those 30-minute appointments through the Patsy Mink Center at the Richard Street YWCA and at the Entrepreneur Sandbox through HTDC. And so I'll drop links into the chat box for how to sign up for those free 30-minute appointments. And we also do direct legal services. I'll send you our website as well. So yeah, keep us in mind. We're looking forward to this presentation today. So thank you very much for attending. I'll turn it over to Greg Ferren now.
Let me say a few more words. I have put a URL in the chat to our website. Bear in mind, it's under reconstruction, so it's going to be updated, but it still gives some basic information. So today is the third in a series of 8 webinars that we're putting on to help Hawaii businesses restart or start. We realize there's been a lot of pain out there, and we want to do everything we can to make it less painful from a legal standpoint for you. So we want to equip you to do what you need to do without having to hire lawyers or use them very much. The rest of the series is every Thursday at 10 a.m. And except we do skip 1 week. So if you look at the schedule on Eventbrite, you'll see that. I ask that you register for each event because I'm not sure that you always get the reminder if you only register for fewer than all. So if you are interested in a particular topic, I would ask that you go back and put your name down for those to make sure you get the reminders. We are recording this today. And so if you don't want to be recorded, then you probably wouldn't want to speak. But just bear in mind that this is an educational series and we're here to educate, not to generate business or billable hours. So we're going to make these recordings available sometime in the future after the entire webinar is done. As attendees, you will receive today's materials. In advance of publishing them, we're going to eventually put them all together into a manual, which we're going to make available as well after April, sometime once we get our act together, we edit the videos and put the manual together. So, but you'll get an advanced copy today, which I will put in the chat eventually as a link to my Dropbox folder. So I'll wait a little while to make sure everyone who wants to come today is that you can get the link. Without further ado, though, I want to introduce Greg Ferren. Everyone, in my experience, has a name. And I'm talking about your business. So if you have a name, you have intellectual property, whether you know it or not. I think most of us are aware of that. And the question is, what do you need to do to protect your name? First of all, can you protect your name? Do you own the name? Or what if there's a conflict? Is there a conflict? And then what can you do to make sure that if there is a challenge, you can win at that? And what can you do yourself without having to pay thousands of dollars of legal fees? So that's kind of the emphasis for today. And Greg's an expert at trademark law, and he's prepared a wonderful presentation for you today, which he will walk through shortly. And then the materials, the chapter he wrote, I will post. And then we'll have time at the end to answer your questions. So feel free to post them in the chat, and we will try to get to them all. So Greg, if I could turn it over to you and say a few words about yourself, and then he's going to share a screen and talk about branding. Thanks, Greg.
Thank you, Greg. So good morning, everyone. Thanks for coming to my presentation. My name is Greg Ferren. I've been a lawyer for over 25 years, which seems impossible, but it's true. I graduated from the University of Hawaii in 1995. And, shortly after that, started to get an interest in intellectual property, specifically copyrights and trademarks. This was when the whole internet boom was starting and was all new. So it was kind of an interesting area at the time. A few years later, I went to Santa Clara University and got a Master's of Law in Intellectual Property. And ever since then, I do a variety of stuff, but part of my practice has been copyrights and trademarks, as well as some patent litigation, but I'm not a patent lawyer where I can prosecute, register patents with patent and trademark office. You know, as Greg and Kat as Greg was saying, we're going to talk about your business name, your brand, your trademarks today. So let me get started and share the screen. Okay, is that working? Oh, wait, hold on. There we go. Okay, does everybody see the screen? Is that working? Okay, so the name of the seminar today is Create Your Brand, How to Protect Your Name and Logo. Okay, so the significance of your brand. It is a business asset, like all intellectual property. And people may not think of it that way, but it is actually it could be one of the most important business assets you have, because it allows people to find your product or service. So when they pick your product off the store shelf, they'll know it's yours. Or when they go to a website, they'll know it's your website. So I think that's the most important part of having a brand or a trademark or a trade name. But it also has other important benefits to it. People use it to sort of create the image of their business. It builds customer loyalty. And there's probably many more benefits of having a good brand name, brand program. So as far as protection goes, this falls under the umbrella of intellectual property. By far, trademarks are the most important area when it comes to brand protection. Copyright can also come into play. In very limited circumstances, even patent law could apply. Trade secrets is sort of the fourth leg of intellectual property, but that's not really applicable to branding, because it's that you're trying to keep things secret. And with your brand, you don't want it to be secret. You want it to be out in the public. Okay, so what is a trademark? A trademark is any word, phrase, logo, sound, color, smell, or really anything that we can sense that informs the customer of the source of a good or service, of who's manufacturing or selling this good or service. So I gave some examples, the word Google for search engine, that Nike swoosh that they have on all their shoes and shirts and stuff. McDonald's, the phrase, I'm loving it, McDonald's, the color pink for Owens Corning insulation, When you turn on your computer, if it's a Microsoft, you hear that little chime. That's also a trademark. So, I mean, it could really be anything that's that you could sense and that identifies a product or service.
Hey, Greg, before you jump
Yeah.
to the next slide, would you mind putting your slides into presentation mode? I think some of the attendees are having a hard time seeing it.
Let's see.
And if you could speak just a little louder, I think
Okay.
that'd be great as well. Thank you. Sorry to interrupt.
Try to minimize. Sorry about that.
If you click slideshow at the top.
Okay, there we go. Okay, is that better? I'll try to scoot a little
Yes, thank
closer.
you very much.
Can you hear me okay? All right.
You sound great. Thanks.
Okay. Okay, so ownership. Basically three requirements. One is that you're the first to use that mark in a particular geographic location and in connection with a particular type of good or service. So if you're the first of your competitors to use a mark in Hawaii, it's your trademark in Hawaii. If you're the first to use it in the United States, you're the owner in the United States. Generally, it's only applies to your category or class, they call it, of a good or service. So another business that's in a completely different line of business could use the same name, generally, unless you're McDonald's or Nike or some really huge company. They can preclude everyone from basically using it. So once you start using it, you're in that location for that product, you basically own it. You don't actually have to register it, but there are significant benefits. So what is infringement? Infringement is when someone is using the same, but not just the same, also a similar mark with a competing good or service. And the test, and really the whole point of trademark law, is not to confuse consumers into mixing up products. So the test is, are consumers likely to buy a competitor's good when really they meant to buy your good? And the reason for that is because the trademarks are too similar, or the brand is too similar. So I gave the example of Apple records and Apple computers, where they had several lawsuits, but the big one came when Apple started with iTunes and got into the music industry. And so you can see Apple for two companies. Apple was the Beatles record company. Okay, so selecting your mark. It's important to do your due diligence with your brand and your mark early on, because the last thing you want to do is, decide on your brand name or your trademark, put up your website, maybe get someone, a graphic designer to do some artwork for your mark, start selling your goods, and then get a cease and desist letter from a competitor who has superior rights in a similar mark. So it's important at the very start to get it right, because you don't want to have to start from scratch again after you're already in business. So the first thing you have to do is select something that actually would qualify as a trademark. And then the second step is to do a clearance search to make sure there's no one else out there that's already using the same or similar mark. They sort of pigeonhole marks into a few different categories. They call them strong marks, weak marks. Arbitrary or fanciful are considered strong marks. So like Google or Xerox, completely random. I'm sorry, something else is fun. Are completely random words, basically. They have nothing to do with the actual product that's being sold. You know, the word Google has nothing to do with search engines. I believe Xerox was just a completely made up word. So those are considered very strong. They're just completely random, they're arbitrary or fanciful. Generic marks or merely descriptive marks are not considered strong, they're considered weak. So I gave my own business name as an example of a descriptive mark, the Law Office of Gregory A. Ferren. So that would not be considered a strong mark, it would be considered descriptive. But sometimes the descriptive mark works for your business, especially if it's your name. And really, our names are all of our trademarks. Generally, that would not qualify for registration. If you use it for 5 years, in some cases, they call it acquired distinctiveness, and you can get it registered. But generic marks are never qualify for registration. So you can't, you know, manufacture computers and call them computers, because that would, the point is, it would sort of foreclose all your competitors from even describing what they're selling. So you can't call you can't use the product name for your trademark. That's generic. Okay, so how do you, once you've chosen a good name, how do you make sure it's okay to use that name? Well, you can start by just searching the internet, you know, typing in the name that you chose, you know, the type of product that you're selling, see what pops up. You could go to the uspto.gov website, which is the United States Patent and Trademark Office. There is a link there that says search trademarks. A little bit of a learning curve, but I mean, it's not that hard to figure out how to use it. You would probably do multiple searches. If your trademark's 2 words long, you might want to search both words together, then each word separately. You know, maybe if your mark has another word that sounds similar to it, you may want to search that other word. There's a way you can search for designs, for example. Like there's another link that has design searches, and you've got to type in the design, and you know, there's a drop down. You can pick design description. So if you have a triangle in your trademark, search for registered trademarks that have a triangle in them. So, you know, it's good to spend some time doing that. You can look at state registration sites, such as here, the Department of Commerce and Consumer Affairs. You can, at the DCCA website, you can look under business name search, and you know, do a similar type of search you would do at the USPTO site, and see if anybody registered here in the state, but you know, they may not be registered with the Patent and Trademark Office. And then you can also hire third-party companies that will do searches for you. And yeah, some of them are good. They'll search all the state registration databases, and of course the Patent and Trademark Office site. I guess other resources as well. In this day and age, you know, it's, in the old days, it was almost necessary to use these third parties. In this day and age, it's not. With everybody having a website, it's not think as critical. What's happening? Sorry, seems like mine. Okay. Okay, so registration. If you want to register federally, it's $250 to $350 fee, and that's per class of goods. So if you sell like shirts and hats, that would probably be one class. So you pay, the filing fee would be $250. But if you're selling shirts and stickers, probably two separate classes. So you would have to pay $500 in filing fees. And by class, there's something called the international classes, which is what the trademark office uses to decide how many classes of goods you're applying for. There's the TIAS Plus application, the TIAS Standard application. The main difference, I believe, is just that for the TIAS Plus, you select your description of your products from a manual drop-down list that they have. So if you can use that for the TIAS Plus, that's better because it's cheaper. And the descriptions are already there for you, so you don't have to worry about describing it wrong. In order to register, you generally already have to have started using the mark. So you're already selling goods under the mark's name. There's an exception called the intent to use application. And that's where you apply under section 1B, it's called. And you have 6 months to show that you've now started using it. You then file a sample of use, like an affidavit or declaration saying you're using it. It's 6 months, but you can generally get an extension or several extensions. Okay, so what are the benefits of getting a federal registration? Because it's not really required for you to be a trademark owner, but there are benefits. One, it gives you this nationwide presumption that you're the owner. Two, it gives public notice that you own the mark. Three, your mark is in the database of the trademark office. You can use that little R circle symbol next to your mark. You can sue infringers in federal court. And you can obtain foreign registrations just based on your US registration. So there are good benefits to getting federal registration.
I didn't really feel anything anymore.
So you apply online to register. Just the basic sort of information about your company, the who owns it.
Sorry to interrupt, Greg, 1 second.
Sure.
Rourke, could you please mute yourself? Oh, sorry. Thank you.
Okay, sure. So yeah, you type in sort of the information about your company or yourself if you own it individually. You will have to type in the mark, or if it's not just letters, you upload an image of the mark. There's some descriptive information that you have to type in. Then you go and select what types of goods or services your mark applies to. You make an assignment of either 1A or 1B. 1A means you're already using the mark. 1B means you're doing an intent to use application. If you're already using it, they ask for a specimen that you have to upload. And nowadays it's usually a web page, but it's got to, if it's a web page, you should show like sort of where you buy the product, maybe not the front page of your website, but where it shows a picture of the actual product, the price, and a link to the checkout. And it just has to be one sample, so you don't need to show like every shirt that you're selling, just one shirt, how people can buy it. But if you don't use a web page, it can be advertisements, brochures, labels, point of sale displays, anything that shows that you're actually selling goods under this trademark. You'll need to decide when you actually first use the mark, which isn't always clear cut, but you should decide on a date. Maybe you started selling it to friends or something, then you launched a website. A lot of times people use when they launch the website for the date of first use. And it is significant because even though federal registration gives you a presumption of nationwide rights, there's an exception to someone who may have been using a mark locally somewhere, maybe in one state. And if they were using it before your first use, they could make an argument that it's they're the owner wherever they were using it. All right, and then when you enter all this stuff, you there's you check some boxes where you're swearing that this is all true, and then you do an electronic signature, and then you can pay at that time, or you can save your application if you want to go back and check some things. And it downloads this some sort of file that you save on your computer. Next time you go back to the website, you click on that file, and it'll fill all the fields in and stuff for you, so you don't have to start from scratch. Okay, so after you've submitted your application, hopefully there's no issues, and after a few months you'll get an email that says, okay, the trademark examining attorney has not found any problems, and we're going to publish your mark for opposition in what's called the Official Gazette. And that's something for the public to look at, to monitor if anybody's trying to register a trademark that's similar to theirs. So it's in the Official Gazette for 30 days. And if no one objects, then you get another email saying that your mark's going to be registered. Now, if there are problems, usually what happens is you get an office, it's called an office action from the trademark office's attorney, and you have to respond to that. If you don't respond, your registration will be rejected, your application will be rejected. Now it can be something minor, like they want to change what the description of the product, basically, or it can be like a serious problem, like your mark conflicts with another mark that's already registered, or your mark is too weak, it's descriptive, or it's generic. And in that case, you have to decide whether you want to put in the work to dispute it, or pay an attorney to dispute it, or just sort of give up and just, you wouldn't get federal registration. You could perhaps still use your mark if you want to, and if you feel there's no risk of infringement of someone else's mark. So, if there are office actions and problems and you're paying an attorney, that's where the cost could really run up for registration. You could also register here in Hawaii at the state level, $50 filing fee, so significantly cheaper. It's a much shorter process. Someone in the old days, they used to just seem like they were just kind of rubber stamp applications, and you submit your form and they would just get registered. Now they do take a look at it. but they're not, as I don't think they scrutinize as much as at the federal level. And, they're not, I don't know if I don't even believe they're attorneys who are looking at it. And sometimes some of the issues they bring up are questionable. But you're more likely on a questionable trademark to successfully register at the state level, I think. The problem is there aren't really a lot of legal benefits you get for registering at the state level, not like you do with the federal trademark office. But it does provide a legal notice that you're out there using your mark. You can, there are some things that the DCCA does, like if you want to challenge somebody else's mark who's been registered here, you could have a hearing and they could, maybe cancel someone else's registration. All right, so now you've got your mark registered. So what should you do? The best practice is to monitor your mark. I know a lot of people just don't do that because it's time consuming and you're busy with other things. But it is good to see if anybody else is, any competitors out there using the same or similar mark. And if they are, then you should do something about it, because if you let too many people copy your mark, there might be so many people using the mark that you end up not only losing the benefits of having this mark distinguish you, but you could even legally lose the right to that trademark under what's called naked licensing, where you just basically let too many people use the mark. It becomes too rampant. So usually the first step is to send a cease and desist letter. Hopefully that works and they stop using the infringing mark. If it doesn't work, then you consider filing a lawsuit. If you're registered federally, good idea to go to federal court. I guess another avenue, if you find someone has registered or is attempting to register a mark that you believe conflicts with yours, you can file a petition with the Patent and Trademark Office to cancel their registration or reject it. Like if you happen to look at the official Gazette and you see someone with a pending registration. And I mentioned a couple minutes ago, the DCCA has a similar type of process. Okay, so moving on, copyrights. These are original works of authorship fixed in any tangible medium of expression is the definition. So what that means is as soon as you create something original, a drawing, some music, some literature, as soon as you put that on paper or on your computer, it's a copyrighted work. You're the copyright owner. So when we think of copyrights, we usually think of, like I mentioned, books, music, drawings, movies, sculptures, artistic type things. But they can also apply to trademarks sometimes, if the trademark has something particularly creative about it. So I believe like the Starbucks mermaid picture might be copyrighted, but something like that, where it's like it could sort of be a stand on its own piece of art or something, or drawing. And you can apply for both trademark protection and copyright protection for those types of works. So you can register at the Copyright Office. The website is www.copyright.gov. There are several forms there for you to choose from for different types of work. But usually for copyright, it would be the form for visual works of art. One important thing is to make sure you're actually the copyright owner, because it's actually the creator is usually the owner. So let's say your buddy is really artistic and you ask him to draw a nice logo for you, a good picture for your logo. And and there's no contract saying it's a work made for hire, he's not an employee. He's actually the copyright owner. So just because your company's using it, they would not be the copyright owner. So to make sure you're the owner, either you create it yourself or you have an employee who's doing it in the scope of their duties, or you get a contract with an outside party that says it's a work made for hire. And if you haven't done that, you can still become the owner after it's created with an assignment where they assign the work to your company. So why register? Well, it's cheap. It's only $45 to $65 now for the filing fee. So a lot cheaper than, doesn't matter how many types of goods or anything you sell. It's easier. It's not scrutinized generally as much as trademarks are. So it's probably a pretty good chance that it'll get accepted. If you register, well, it's a prerequisite to filing a lawsuit. It's not a prerequisite to being the owner, but it is if you want to file a lawsuit. You can recover attorney's fees in your lawsuit if you win. There's something called statutory damages for copyright, where you're not actually having to prove how much money you lost because someone infringed your copyright. And it can be up to $30,000 each infringement. And if it's a really willful type of infringement, up to $150,000. And if you register within 5 years from when you publish it, there's a presumption that it's legally valid. And you can also get U.S. Customs to seize, pirated type works that are being imported. Sorry. Okay, so copyright actually refers to several rights. And they're called a bundle of rights. You can make copies, you can distribute copies, you can make derivative works, like you can make a sequel or something, or build upon the first work. You can display or perform the work publicly. So anybody else who tries to do any of that, make copies, display your copyrighted brand or logo, is an infringer. Copyright lasts for a long time, 70 years generally, or if it's anonymous, 95 years from the first date of publication, or 125 years from when it's created, whichever ends first. And by the way, trademarks basically last until you stop using them for the trademark owner. And then here's some examples of a notice. So you can use the C's with a circle, or copyright, and you can put the year and the name of the copyright owner. And that helps provide notice to people that it is copyrighted. Okay, and then lastly, patents are usually for inventions, scientific inventions, technological inventions. But there's something called a design patent, which protects sort of the distinctive way that an actual product may look. And so an example was that curvy Coca-Cola bottle, that's been around for a long time. They had a design patent on the shape of that bottle. The design itself can't be functional. So it's not intended to prevent other people from using that design if it performs some function. So it's just got to purely be for design purposes. Costs probably several $1,000s, including attorney's fees. It lasts for 15 years. So I believe that's it. Yeah, so we can move to some questions now.
Hey, Greg, thank you so much for that.
Sure.
You can stop your share now. If we'll get to the questions, but could I just throw out a hypothetical? Because if
Sure.
everyone's like me, I'm sitting here thinking, this is way beyond me, but I'm a small business owner. What do I do? I mean, you've given a lot of details, but I can't fathom those. So, so my hypothetical is I'm starting a business called Kalbi Shack.
Okay.
Okay. So, and in addition to a restaurant, I'm going to sell Kalbi sauce online, nationwide or worldwide.
All right.
I don't want anyone using my name, but my budget for legal is $1,000 total, including fine fees or anything, which is, I think for a lot of entrepreneurs, their budget is zero.
Yeah.
So that too. What should I do to protect my name, my trade name, my trademark, my other rights, my secret sauce? But, as a real practical matter, what do you think I should do? And put your business hat on, not your lawyer hat. What would you?
Yeah, well, I mean, so you've decided on a name. So the first thing you should do is look around to make sure nobody else is using that name.
Well, I have Kalbi Sauce LLC registered in Hawaii, so I've already done that.
Sauce LLC.
Yeah.
So yeah, I mean, I'd make sure nobody else, you don't have competitors already using it before you start selling under that.
Okay,
name.
how do I do that?
Well, you can Google, you can search the
Okay,
internet.
that's good. That's
Right? You can
do
search
cost
for
free.
Yeah, you could go to the Patent and Trademark Office website. and search
Okay,
for
that
the-
uspto.gov, put the name
Right.
and
Right. You
see
can,
what's out there.
you
Okay, I've done
can-
those things. I haven't seen any
DCCA.
conflicts. Yeah,
Okay, so good. So there's no conflicts.
so far so
with the
good.
DCCA. At $1,000 budget, you probably don't want to hire a third-party company to do a more extensive search. And so Kalbi Sauce is the name of your company, and I assume that also or Kalbi Shack is the name of your brand.
Yeah.
Yeah. So I think that's probably creative enough that you could probably get it registered.
Okay, now nobody steal my name now.
Huh?
I'm talking.
Yeah.
Nobody steal my name now.
Yeah. Okay.
Because Greg says it's pretty good.
Yeah.
Okay.
Fine.
So, okay, I've
I
got
have
this
no idea how
name
to make
registered
Kalbi sauce, so.
in Hawaii, and you talked today about doing a Hawaii trademark registration.
Yeah. So
What should I do?
all right. So you go to the DCCA website, and there you go to their online resources. There are forums for registering a trade name. They actually have 3 forms, I believe, for trademarks, trade names, and service marks.
Now, if I have the name as an LLC, my lawyer friend told me I don't need to do a trade name. Was he telling me something wrong? Because I already have the company name, Kalbi Shack.
Yeah, a company name is not necessarily a trademark.
Trade name. No, it's a trade name.
Okay, well, yeah, a trade name is a type of trademark, but yeah, so it's not necessarily what you would use to sell your product. I mean,
But if I have a Kalbi Shack LLC and I filed a trade name, a business name for Kalbi Shack, isn't that redundant?
No, I would file the trade name as well to provide public notice that it's actually something you're using as a trade name, not just a company
That's
name.
interesting, because when I asked the DCCA, they told me I don't need to do that.
Well, yeah,
It serves as
don't believe
same
everything
purpose.
you hear from the DCCA.
Okay.
But yeah, I think well, I'll put it this way. I think there's benefits to filing the trade name. So
And it's cheap, right? So I'm not going to blow my budget.
Yeah, $50 for the DCCA. Like I said, you don't get nearly the legal benefits you do if you were to register it at the federal level.
Okay, so
But
I don't want to
it does create a
monopolize your
couple
time.
friction.
Yeah, I don't want to
Huh?
monopolize your time, you know, so I'd have my trade name, my company name. What else do I do?
Well, so you can look into registering it federally if you're going to sell this nationwide.
Can you do a trade name federally?
Yeah, yeah. It's like
Well,
I said, it's basically a type of a trademark.
Gotcha. Well, my understanding, there's no federal registry for trade names, but you have, if you have that name that you use for a product or service, you can register it federally.
Right, right. So, and you're using Calvi Shack to sell your sauce, right? That's
It's a
the
business.
marketing.
It's a business. By the way, we're getting some questions about Greg needs to speak up. There's
Okay. Sorry.
no, there's two Gregs here. Is it Greg
Yeah.
Kim or Greg Ferren?
It says Greg Speaker, so
Okay. Well, I'll move a little.
not
Is that
you.
better?
Okay. Anyway, just that was my typo. And basically, when I talk to small business, you know, and they don't have a whole lot of money, they have to do what they can. You can do the local trade name, you can do the local trademark or service mark, but that's only to get you local protection. Or you can go to the feds, do that. If you can do the application yourself, which a lot of my clients have done, you know,
Mhm.
the filing fee, but you know, you might make mistakes, but that's okay. Maybe the examiner will correct it for you. So as an entrepreneur without a big budget for this, you know, you can try to do the federal registration yourself.
Yeah, I mean, the Patent and Trademark Office website is pretty user-friendly, pretty easy to navigate. The application is, uh, it's a ugly application form. I mean, it's a lot of colors, a lot of small print, and a lot to read through. But yeah, if it's not a complex trademark situation, I think it is within the abilities of lay people.
Okay. Kat, could you maybe go through the questions in the chat to make sure we cover those?
Sure, yeah, and I also got a couple questions that were directed to my little message box. So since we're talking about trademarks, one question, just to be clear, trademark registration at the federal level, does it trickle down to state?
Yeah, it covers all the states. So you know, if you get it, you're the presumption that you have nationwide rights.
Okay.
Someone
Great.
could tell someone who's already doing it somewhere else, like in a state, could say, "Hey, no, you know, you're wrong. I was here first." They could bring something up with the trademark office to challenge yours. But generally, though, it does give you a presumption that you have nationwide rights.
Got it. Okay. I'm going to package a couple of the questions into one, since a lot of people are worried about infringement, particularly as to copyrights. You know, what is the standard for infringement? What if, you know, there's a slight modification, say like a 10% modification or a change of the color? What is the standard for infringement?
Yeah, slight modification doesn't save you. Yeah, I mean, they'll just sort of look at the whole look and feel and decide whether, you know, a court will decide whether they're too similar and it's a copy. But yeah, they'll look at access. You know, was there an opportunity for access, and you know, was it copied? And I mean, if you completely create something on your own without ever seeing this other work, you know, then it's not copyright infringement because you haven't copied them. But you know, if this work that you see it everywhere, everybody knows about it, and then you come up with something that's, you know, pretty close to it, then it's, you know, copyright infringement. So you should be concerned about that.
Another question that we got from a couple people is, let's say we know that somebody else is infringing on our mark.
Mhm.
What do we do?
Well, the first step is usually a cease and desist letter.
Do you have to be an attorney to send a cease and desist
No.
letter, or can you send it yourself?
You can send it yourself. Hopefully they take it seriously. Maybe they'll take it a little more seriously if it's from an attorney. Sometimes it comes from an attorney and they still don't take it seriously. But yeah, you don't need an attorney to send a cease and desist letter. I'm sure you could find samples online. If they continue to infringe, I mean, it's either you file a lawsuit, or maybe there's something you can do at the agency level, like if they've registered it here in the state, to try to get their registration canceled. Yeah, but I mean, some people they don't care. They're off in some foreign country. They're hard to really get to by the courts, so they'll just keep infringing.
Since we're talking about foreign countries, what do you have to do to protect your intellectual property abroad?
Well, for trademarks, for example, you can, if you have a U.S. federal registration, you can use that to apply in, whatever countries you're interested in, if they're part of the treaty, which is most countries that you would probably care about. If other than that, you might be able to, for copyright infringement, you could seize products that are coming in. But you might just have to get a lawyer in the other country. If you could sue them here and maybe get a judgment against them. But it might be hard to collect anything if they're really offshore. So, and there may be problems where you try to sue them here and the court says, well, we don't have jurisdiction over them. So yeah, it's very difficult. It's a real problem when the infringement's happening.
I think if you go
overseas.
international, you probably need a lawyer at that point. That might be do yourself, like unless you can speak Japanese or something, or other languages, but and know the law. But I think for US, certainly you can try to do it yourself. The flip side of that is, what if you get a cease and desist letter and you don't have money for a lawyer?
I think it depends on the context. For one, do they have a good point? And if they sue you, are you going to be in trouble? Or
let's say that you have a good defense. You think you have a good defense.
Yeah, well, then you might respond to them and say, I disagree. I don't believe it's infringing. They could, of course, file a lawsuit. They don't have to be right to file a lawsuit, and then you'll have to defend yourself. You could try to negotiate with them and, say, okay, I think you're wrong, but, whatever, here's a little bit of money, and, we'll agree to let each other coexist, or, so you could come up with a resolution that would allow you to keep using it without the risk of a lawsuit. Or, if you really feel strongly about it, you could just call their bluff, or tell them you disagree, and let them do what they're going to do. They might just go away, or they might, file a lawsuit or ratchet things up some other way.
So hit them back with a letter and then hope for the best.
Yeah, you could ask for more details, like, well, when did you actually first start using it? Or you could try to find that maybe you actually used it first. And then, now you have a claim that they're infringing your trademark.
If you used it first, say in Hawaii, and someone registered it nationally after you, my understanding is you probably can keep using it, but you can't expand beyond Hawaii. Is that generally the answer?
Yeah, you're the first to use it in a geographic location. You keep that, even if they have federal registration.
But if you try to go outside Hawaii, they could probably stop you at that point.
Right. And it can be more complicated today because everybody has a website. So you might have actually, maybe you're a Hawaii company, you're here in Hawaii, but you started doing sales in other states before they even got their registration. So, you could have an argument that you actually were using it nationwide before they got the registration.
Okay, let's see. We have time for a few more questions if there are any. Kat?
Yeah, I have a few more. So one question is, we're talking so much about infringement, and what do we do to put people back in their place? But are there any preventative things that can be done?
Well, I think from the start, having a really, like I said, a strong trademark name that's fanciful, arbitrary, that makes it harder, I think, for people to challenge your mark. And then, the legal protections we talked about, getting it registered, the searching, the due diligence to make sure there's no one else out there already, and monitoring, checking the official gazette, checking the internet, calling your competitors, and then when you find someone who's possibly infringing, doing a cease and desist letter.
So we have kind of a specific question. Greg, I'm going to give it to you. Are you familiar with NFTs in the crypto space? And if so, how does copyright apply?
I'm not familiar with that. Sorry.
Okay. Another question. What does it mean when people have the copyright symbol with the year at the bottom of their websites? What are they claiming they have a copyright to? The content of their website?
Yeah, I would. Yeah, it should be the website is what they're claiming if it's on their website.
A related question, Greg, is my understanding is it's no longer required to put the C under copyright law, that you automatically own the copyright. But is it still a good practice in your view to do that?
Yeah, I think yeah, I think so. It's another way to show that they have notice, or, that the public has noticed that you're claiming a copyright. So I think it's a good idea, and I think most companies are still doing it.
Okay, are there any further questions, Kat?
That's all I have.
Well, we're going to wrap up here. If you have any follow-up, Greg is generously agreed to stay online for a few minutes to meet with you. Of course, it'll be in a group setting. And I've put his email in the chat for those who want to reach out to him. Our next webinar is next Thursday. And I can't remember the topic right off the top of my head. It is working with the state. So how do you get free assistance from the state agencies, including the DCCA that we've talked about today? But Kaika and Kimmy are going to talk about the full array of services that you can tap in on if you're starting a business. And I want to thank Greg Ferren for sharing his time and expertise with us. So big hand for Greg. Yay. And thank you all for joining, for participating, and for all you guys do in Hawaii to create business, create jobs, because that's the lifeblood of any community is small business. So we applaud you. And if you need help, please reach out to us and we'll do what we can to help you. So with that, I guess we will say goodbye to you and hopefully see you next week. So anything else, Kat, that I didn't think of? Okay. All right. Thank you so much, everyone, for joining. We'll stay on, as I said, for a few more minutes and to answer any follow-up questions. Thanks, Greg. Great job.
Yeah, thank you.
That was a lot to get through and in the midst of and everything. So appreciate it. I did post your slides and your chapter to everyone, so I hope that was okay.
Yeah, of course.
And we'll be in touch with you as far as the manual. We'll probably go through some sort of editing process and work with you on that.
All right.
After the series is over.
We do have one question, I think,
Yeah.
Gloria.
Yes, Greg. Many years ago, I filed and received a trademark from a national trademark for my service. And it was for a cable television channel, so it's analog. Now I'm relaunching the business digitally online, so it's a different category. Plus that particular trademark that I had federally expired.
Right.
So I would have to start all over because the internet didn't even exist back then,
Right.
right?
Mhm.
But can I claim that particular early use date from
The
years
early
ago?
use date.
Because the content's still the same. It's just that the delivery is no longer analog, it's digital. But the business was spread across several states.
Yeah.
It was-
Well, yeah. So you used it, then you kind of stopped using it for a while,
yes,
and you restarted again.
yes.
Yeah, I've never come across that issue. My instincts are you'd probably have to start from the newer date. That being said, I don't know if the examining attorney at the trademark office would really pay much attention to if you put the old date in there. I mean,
I had a few thoughts. Number one is the concept of abandonment in trademark, and number two,
yeah,
once I understand, once your trademark filing goes permanent, I forgot the exact term for it, then it cannot be rescinded. You know, it's declared final and permanent. I think after 5 years. So
yeah,
things
yeah.
that
You have
occur
to.
me.
Yeah, you've got one. also at the
It was
ninth-
permanent. It lasted for, I think I had it for 10 years or 5 years, but it was permanent. I did get that. I put it on my wall. It was nice, you know,
How about
across
the concept of abandonment, though, Greg?
abandoned.
Yeah, so you usually file one thing after the 5th year between the 5th and 6th year, and then the 9th and 10th year again. So you got to the 10th year and
Yes.
you filed so it's probably still a live trademark. I mean, if you go on the Patent and Trademark Office
Okay,
website and looked it up,
okay.
it probably would be live. So, but if you're in a different class, I'd probably do a application again. And is it the same company, same owner?
No, it was in Washington, DC, and so we filed it in Hawaii. Also, other organizations have kind of taken the name. I've
Okay.
seen like Lehigh University has used it for one of their programs and their MBA school. So I've seen other things on the internet using the name that I had years
Yeah.
ago.
But we might need to do some cease and desist letters
Yeah. And,
Okay,
to retain your rights. I
okay.
hate to cut it off, but we only have Greg for a few more minutes. So Gloria, I did put his email in the chat if you want
I
to
will, thank you.
directly. So are there any other people who are still on who have questions? Because we have 6.
I've actually got a question for Greg if nobody else does.
sure.
Fire away.
So I went onto the national database. Recently, me and 2 of my friends, we launched a company that's going to be going into commercial development, property management, and property sales and purchasing.
Mhm.
And so I see online that there are 2 other companies with almost exactly the same name. One has one is the Hyperion. Another one is Hyperion Robotics, whereas we're just called Hyperion. And both of them have construction services, the planning, laying out, and custom automation, construction of environmentally sustainable modular buildings, blah, blah, blah. And then real estate development and services in the field of mixed use properties. So would we be able to file a federal copyright or a federal trademark if we're
Okay.
similar but different and the names are also different enough? Would that be clear?
Yeah, it sounds like they're pretty similar names, and if they're both in real estate,
Mhm.
maybe the construction field might be different enough. But yeah, if they're claiming real estate development and that sort of overlaps with what you guys are doing. What are the difference in the actual names again?
One is called just the Hyperion, and then the other one is called Hyperion Robotics.
Okay, and does the robotics is also in real estate?
Yeah, apparently it almost sounds like they're 3D printing modular homes for distribution.
Okay.
Hey, Christian, I mean, it's a factual question, so it's hard to give a definite answer. I feel
Yeah.
worried about you if you,
Yeah.
number one, because if I were Hyperion Robotics, I say, hey, people call us Hyperion, you know, and number two, but also, and this is a question for Greg, if you file the trademark, they're certainly going to object to it. And then you have a day in court with the trademark office, right? To argue your point. So is that a strategy?
Yeah, I think even before that, there's a good chance the trademark examining attorney will raise the issue and say, you know, there's already similar mark that's registered in the same field.
Why don't you call yourselves Hyperion, not robotics?
Anything but robotics.
But if you just maybe, my guess is if you, I mean, if you start with Hyperion, no matter what you add to it, I would say there might be a confusion, which is the ultimate standard, right? Is a consumer that it's the same company somehow.
Yeah, that was an issue that we had registering with the state because there was another company named Hyperion, so we ended up having to add realty to the end of our name.
Hyperion's pretty generic, right? I think, even though it's a fancy word, it's generic. But
every state's got loads of registered businesses under similar names, variations of the name, all pretty similar stuff.
Yeah.
Okay.
I think that might be a tough one to get registered federally.
Okay. All right. Well, Greg, thank you very much.
I think that's the end of our questions. Thank you so much, everybody, for hanging on. Have a great day. Stay safe. And hopefully we'll see a number of you for the coming weeks. All right. Thank you again, Greg. Awesome job. And I'm sure we'll be interacting with you too. So, all right. Bye, everyone.
Okay. Thanks, everyone. Bye.
Thank you.